Would you give an infant alcohol, or would you let a 4-year-old play with knives? Would you let a 9-year-old vape, or a 12-year-old operate a motor vehicle if they wanted to? Well, what about a 16-year-old? Should they be allowed to have the ability to withhold medical information from parents and consent into things that they are incapable of fully comprehending? On September 30th, 2024, while attempting to refill a Class 2 medication for my daughter, who is 16 and legally still a minor, I was abruptly informed by her pediatrician that legally they would no longer be communicating with me and would be ceasing communications with me until further notice unless they had her written consent to do so. Today, I want to speak about why the law pertaining to HIPAA regarding children that are age 16 in the state of South Carolina is unsafe and why it does not make sense. It is my goal that by the end of this speech, you will see the importance of this matter and agree that this law needs to be reconsidered. I will be talking to you about why this is unsafe due to a 16-year-old's mind not being fully developed and why it is illogical that parents need the written consent of a minor to continue with key essential parts of their parental duties. Before I speak on these issues, I would like to give you a quick rundown of what this law from HIPAA allows your child at the age of 16 to do in the state of South Carolina. First, this law allows them the ability to decide whether or not they want to withhold all medical information from parents going further. It also allows them to consent into medical procedures without needing the consent of anyone else. This means that without their permission, you are no longer privy to any type of medical information that transpires between a provider and your child, according to the 2024 Express Pediatric Care's online confidentiality clause. This is backed up between myself and Sweetgrass Pediatrics in a personal communication from September 30th, 2024. Restricted information would include, but is not limited to, any diagnoses, lab results for things like sexually transmitted diseases and substance abuses, or it can pertain to things like mental health services obtained. However, as I stated, teenage brains are not fully developed enough to make these types of decisions, and they are certainly not developed enough to withhold this type of information. In an online PDF from the National Institute of Mental Health in 2023, they state that the prefrontal cortex is the part of the brain that is responsible for planning and prioritizing and making good decisions. Unfortunately, they note that this is one of the last areas of the brain to fully mature. Next, I want to speak about why this is unsafe and should be reconsidered. While some may think this is purely an opinion of a scorned parent that may have been denied medical access to their child, this is simply not the case. This is, in fact, unsafe, and this is an issue because as a parent, our number one priorities are the health, safety, and well-being of our children. In an online article published in 2024 by Dr. Christine Dietz, she writes that we have been forced to rethink our understanding in brain development. She goes on to say that the teen brain is not fully developed, and because of this, teenagers are making decisions primarily using their highly emotive and impulsive limbic system and amygdala because the rational prefrontal cortex is not yet fully developed. So what does this mean? Dr. Dietz goes on to explain that this means teenagers act before they think. They are risk takers and they are not yet capable of planning or prioritizing, nor are they able to see the relationship between their actions and the short and long-term consequences that are associated with those actions. This potentially could be a life or death situation if a child is prescribed medication that is either abused or taken incorrectly. Even if it is taken correctly, it could still cause adverse side effects or an allergic reaction, and this is information that a parent needs to know. In an online article by Nations in 2024, she explains that parents act on behalf of their children because it is presumed that what the child lacks in the capacity to understand that the parent possesses. The National Institute of Mental Health in their online PDF from 2023 goes on to say some things you should know about the teenage brain are that they do not fully develop until the child's mid-20s, that the teen brain can react so negatively to stress that it can actually induce stress-related mental illnesses, and that most teenagers do not get the sufficient amount of sleep, which further hinders them in things like impulse control, paying attention, and making good decisions. Third, I will be talking about why this just does not make sense. Imagine how many things a teenager is legally not allowed to do simply because they are not old enough or mature enough to handle that responsibility or understand that situation. Things that include like taking out a loan, voting, joining the military, buying tobacco, signing a lease, applying for credit cards, filing a lawsuit, picking up a controlled medication, like in the case of my daughter. And these are just a few things that are named on an online article from Heffernan in 2023 entitled 50 Things You Can Do When You Turn 18 and a Few That Don't Happen Until You're 21. So why can't a minor do this? Simply put, it's just not a good idea. So ask yourself, why is the ability to make medical decisions not on that list? Going back to Nation's online article from 2024, she mentions perhaps the oldest noted fundamental right that a parent has. That right says that a parent has the right to parent how they see fit without interference from the state. Unless there is a reason to be deemed unfit or a medical choice has been made that should be ethically challenged, parents have the right to make medical decisions pertaining to their children, as mentioned in an online article from DIPPA in 2018, entitled Parental Decision Making. Furthermore, the Supreme Court has upheld the Due Process Clause in the 14th Amendment, protecting the fundamental rights of parents, allowing them to direct the care, upbringing, and education of their children. Finally, after speaking about why this law pertaining to 16-year-olds and HIPAA should be reconsidered, let me summarize my points. At the beginning of my speech, I said I would be speaking about why the age of 16 should be reconsidered regarding HIPAA and what it allows minor teenage children to do in the state of South Carolina. It allows them to consent to their own medical treatment without the consent of anyone else, and it allows them to withhold medical knowledge from parents. This is unsafe because a teenage brain is not fully developed and they still rely on the guidance of their parents. This is illogical because with so many things that a teenager is not allowed to do, why would the ability to make medical decisions be one of the things that they are allowed to do? Furthermore, the state respecting the medical privacy of a minor child blatantly disrespects the fundamental right of the parent, which is protected by the Constitution. I ask that you reflect on your right as a parent to parent how you see fit, without interference from the state, and hopefully with, but if not, certainly without, the permission of a child who you are legally, financially, and morally responsible for until the legal age of adulthood. The age regarding 16-year-olds in HIPAA needs to be reconsidered until at least the legal age of 18. I hope that I have encouraged you to see and agree that this law must be reconsidered so that all parents may continue to play an active role in the health, safety, and well-being of our minor teenage children until at least the age of 18 to ensure that all needs are being met continuously and safely.